We have with us an exciting panel, and I'd like to introduce very quickly Judge Kylie Beckhouse, who will chair this final panel. And joining Kylie is the former boss of mine, the Dean of the School of Law at Western Sydney University, Professor Anna Cody. And also joining us from the Melbourne Law School is Professor Heather Douglas. Thank you.
Well, colleagues, thank you, welcome. I too want to start by acknowledging the traditional custodians of the land that we meet on today, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present, future, emerging. I was grateful that, I was a bit nervous when John, in fact, introduces it as an exciting panel. I hope we can provide some excitement as we bring this home this afternoon. I did actually also want to make just recognise the people in the room today who are from legal aid commissions and the legal assistance sector. For ease of reference today, I'm just going to refer to you in a job lot as legal aid lawyers. I don't want to cause offence by doing it, but I think as the discussion has emerged today, and it will continue, there can be two no more vulnerable groups in terms of advocating for the legal rights of Indigenous people and families experiencing family violence. And I'm going to use that term as well because I want it to encapsulate not just the generally women who are victims, but the children who live in homes and suffer the consequences of their exposure to family violence, as well as the perpetrators who are very much part of the system and are part of the problem. So thank you to all of the people who work in the sector, and it's incredibly important work. And one of the themes for our session today really is about good lawyering and how good lawyering leads to good outcomes. So to all the law students there, thank you also for coming because you really are also part of the solution. So I want to talk just a little bit about what the problem is. And I know that most of you have heard a lot of statistics over the prevalence of family violence. I'm not going to repeat those statistics, but I just wanted to give you a glimpse of my world. That is a court, family courts. In the period between 21 and 22, every matter that came into the court had to file something called a notice of risk. And that notice of a risk identifies child abuse, family violence, and other risks. This is what we found looking at those stats. Family violence featured in 80% of parenting matters that were filed. There was a risk of child abuse alleged in 70% of those matters. 74% of those matters alleged a child had experienced and been exposed to family violence. In 24% of those matters, there was an allegation that there'd been a recent threat made to either a child or a party in the proceedings. And as a result of that, 80% of those matters were referred to child welfare agencies. That's the cohort we're dealing with. It's the cohort that you in the legal aid sector deal with. It's the cohort that we deal with at the pointy end of family litigation in courts. The approach of the family law courts has been rapidly transforming, and I am going to talk a little bit about that transformation today. We recently launched something called the Lighthouse Model, which was rolled out across Australia, and it was very much in response to years and years of recommendations about how to deal with that cohort of people more effectively. So now there is early risk screening at the point of filing. There is an early assessment and triage of all cases by people who are specialised to do it, and they actually aren't the judges, by the way, and tailored case management for families, including a designated court list. That's all now commenced. But that was part of a suite of other measures that very much affect the people in the legal assistance sector. First of all, there's been a co-location of police and child welfare representatives within court registries. Information sharing has very much improved, so that now as a judge we are able to obtain information from a range of other agencies that will help us to make better decisions about the safety of the children who are before the court. Specialist lists have been designed to minimise, to as much as we can, people who are facing issues like litigation abuse or economic coercion. As many of you will know, Section 102NA is a scheme that has been introduced across Australia to ensure that victims of family violence can't be cross-examined by perpetrators. And of course there have been technological enhancements, somewhat assisted, I imagine, by COVID, but the impact of that is that there is a much better use of technology to minimise the risks for victims of family violence. I'm proud to say that before my appointment I was involved in establishing a scheme called the Family Advocacy and Support Service that has now been rolled out across all registries in Australia. It's a support service that provides at every court registry both legal and social support for people who've experienced family violence. And now that I'm on the bench, I can absolutely attest to the benefits of people having access to those services at the door of the court and inside the court. I wanted to share with you today just practically how investments like these and putting into place recommendations that are made can make a difference. And I say it with some sadness, having listened to Tony talk with great regret about the lack of follow-up on many reports. There's been a lot of reports in family law. We're all exhausted by that as well. But I have to say that at least there has been some movement. And I just wanted to give you a practical example of a case I did. I delivered a judgment last year, very late last year, in a matter called Ramsey and Musa. And it was a very difficult matter, as many of them are. It involved a young boy who'd been ordered, I had to decide whether this young boy should be ordered to move from Sydney to Melbourne and grow up spending time with his father and a lot of people within his large ethnic community. The mother argued she wanted to stay in Sydney and did not want the father to spend time with this child because she was so concerned about risk. To put it in some context, the mother was a vulnerable young immigrant woman brought to Melbourne under an arranged marriage. She spoke limited English, and I ultimately found that she'd been the subject of family violence throughout the relationship. And interestingly, at the time of the hearing, she and the child had escaped to Sydney, notwithstanding and contrary to court orders. I'm going to paraphrase this, but the husband argued, as is often the case in family law cases, that she'd made up all of the allegations of family violence. She was malicious and not a friendly parent. That was the tenor of the argument. And the truth was, as is the case in many complex family violence matters, she was not the perfect victim. There were things that we could be critical of her for. It was, however, the skillful representation that she received from well-trained lawyers who were funded by the government that ultimately meant or led to what I think was the long-term safety of this little boy. It was a very detailed judgment that considered a pattern of behaviours that we ultimately found to be coercive control. And the judgment and the observations of what constitute coercive behaviour was last week endorsed by the full court in a case of Carter and Wilson. Reflecting on the case though, it occurred to me it was a really good case to talk about what comes from investment in services to improve the outcomes for victims and people experiencing family violence, particularly investing in legal aids. In that particular case, the woman initially was represented by the Women's Legal Services in Victoria. She was supported by a range of family violence services, including emergency accommodation, both in Victoria and New South Wales. She was referred on arrival to New South Wales to a specialist domestic violence unit that was offered by Legal Aid New South Wales. And I later found out that she was also assisted by a social worker embedded within Legal Aid New South Wales. They made appropriate arrangements for her to be protected through the court process with a safety plan and a support worker. What else contributed to good outcomes? Well, there was an excellent family report. A lot's been said in the past about dreadful experts in the family law jurisdiction. This was a really terrific family report that helped the court understand the nature of family violence and the nature of coercive behaviour. The internal family report writer had the benefit of a tailor-made Safe and Together family violence training, and that was a recommendation of a report in 2017 following a parliamentary inquiry. As a judge, I had the advantage of having gone through that training, but in addition, I'd also undertaken training through the National Judicial College of Australia. Again, a key recommendation of a previous law reform piece. And I was heavily reliant on something called the Family Violence Bench Book. That was actually published in 2010, but updated in 2022 to include more content on coercive control. And I have to acknowledge our panellist here, Professor Heather Douglas, who joins us and was the project lead on that. As I observed in that judgment, there was much more to understand about culture, and there wasn't enough before the court about it, and it's something that our other panellist, Anna Cody, is going to talk about today. But in my mind, the case does reflect how constant improvements and investments in the legal system can generate good outcomes. Of course, we all know there's still a long way to go. In January 2022, the government released a draft family law amendment bill and has sought feedback. I'm a little bit like our last judicial panellist. I can't enter the fray of discussing with you my views on legislative amendments. I will say this though, it would appear to me, having spent a long time on your side of the fence, putting in submissions and attending parliamentary inquiries, that it picks up on many of the recommendations that have been made for how you might amend the Family Law Act to be more responsive to family violence. I'll leave that as a question for later, but I would say it's a testament, in my view, to the consistent advocacies by people in the legal aid system and how they can lead to improvements. I encourage you to read it and provide your feedback. So whilst today I've highlighted good outcomes that flow from the investment of money in the family law system, we can't overlook the consequences of underfunding. Now, my colleagues are going to talk to you a little bit about what good lawyering looks like. I can tell you from a judge's perspective that sadly we see far too many examples of poor representation of the most vulnerable clients, especially, I have to say, when they're publicly funded through private lawyers. And for anyone in the room who's a private practitioner, I don't mean in any way to disparage the very fine work that most people do, but there are some people in the system that let the system down. But I want to ask the question why that might be, and ask you to think about what we can do about it. To represent a victim of family violence in a court, you should be expected to take instructions in a trauma-informed manner. That can take several meetings over a long period of time. Take them through a risk identification process, maybe refer them for a more thorough risk assessment, organise a safety plan, work through interpreters, work with a range of allied health professionals, gather evidence to corroborate your client's case, and carefully draft affidavits. I imagine the work involved by the lawyers in the Ramsey case that I spoke about involved hours of work of that nature. The scope of the work done, I suspect, would never have been covered under a grant of legal aid. Private lawyers doing legal aid work are funded on low hourly rates, and the time allocated is capped. Many good lawyers ignore the money and see it as their pro bono. In fact, I suspect the system has survived on those good lawyers for many, many years. But funding constraints ultimately have a direct impact on the quality of practitioners appearing before courts in family violence cases, and ultimately that impacts on the outcomes for victims and children. And it leads to what I would argue is a dichotomy in the services received by victims of family violence. And that, to me, doesn't seem like access to justice. Children are front and centre of decisions and decision-making under the Family Law Act. Independent children's lawyers, in my view, are critical to ensuring that evidence comes before courts that ensures that the best decisions for children are made. And decision makers need to hear about the lived experience of children growing up in family violence. It's critical to the way that we make decisions. We now know enough about the experience of children, particularly who've grown up with trauma, to understand that they need to feel like they've participated in legal processes. I know legal aid commissions have been struggling for years to keep up with the challenges and also to keep up with funding these important services like independent children's lawyers in circumstances where the funding just doesn't increase. And I don't make these comments today in any way as a criticism of the way that legal aids manage funding. It is the most difficult job in the world. What I do pose to you all as a group is, this is the responsibility of all the players in the system. And we probably need to have a more open and honest dialogue about what are the barriers that we face to achieving good practice. Because I think often the answers are funding. Funding is a real barrier. So the conversation, to my mind, also needs to include things around challenges to service design and maybe funding models that are different to our traditional models that will ensure that families who experience family violence do receive the best lawyering and outcomes possible. So that's my rant on what we might be able to do better. I'm now going to hand it over, first of all, to Heather, who's going to take that topic up. I'd ask you to make any notes because we would really like to have a discussion about some of these issues when we get to the end.
Thanks, Kylie. I want to thank John for the invitation here and obviously also the great work of the Whitlam Institute. It's fantastic to be here with you all. And I also want to, especially after hearing that really heart-wrenching panel before, more than ever, I want to acknowledge the Gadigal people of the Eora Nation and the Aboriginal people in the room today and recognise the extraordinary struggles that colonisation has brought to Aboriginal people. I feel like I'm coming full circle a bit here, and this is obviously wasn't in my script, but one of my earliest jobs, my second law job, was to work for the Aboriginal Legal Service in Alice Springs. And I was a criminal lawyer there for 3 years. And one of the big things I saw while I was there, that women who are experiencing domestic and family violence weren't getting the services they needed. So we worked at the Aboriginal Legal Service with other lawyers in town to set up domestic and legal help service there. And Anna was the first person to work in that service. So I was on her interview panel for that particular job. So it's a real circle here to be hearing that panel just before and now talking about this particular issue. But as Kylie said, I do want to talk about the issue around what makes good lawyering, but I also have another point to make before we get to that. And that is to talk about the missing middle of legal services. And the middle should be kind of that middle third, but unfortunately that is growing significantly. And more people are missing out on legal aid. And I heard legal aid described in the first session as people who were on low wages. Really, I think it's fair to say that legal aid is largely for people on no wages who are on, in receipt of some kind of social security. Few people who are waged are able to get legal services in the context of the wide range of services that are needed for domestic and family violence. So I really want to talk a little about that, because when women do, and I'm particularly focused on women, that's been my experience in terms of my research, but when women who've experienced domestic and family violence do finally manage to leave violence, and often it takes a long time to do that, they're often involved in a broad range of legal contexts. Family law is one of them, but they're often also needing to get intervention orders. They've possibly got issues with child protection as well, banging on their door, trying to get things sorted out as well. There might be criminal matters. Maybe they've been misidentified as an aggressor in a matter. There might also be, for some women, migration issues to deal with. So there's a real suite of legal engagements that can add up to many, many hours with lawyers and many, many days in court. So we know that the cost of just a day-long procedure for a summary hearing, and many of you will correct me on this, but it's definitely over $1,000 a day, often much more, certainly if it's paid for through the private sector. And you'll recall, many of you, the Australian Law Reform Commission's report on family law for the future, which talked particularly about private family lawyers charging fees that were variously obscene, eye-watering, extraordinary and grossly disproportionate. And yet this missing middle are often confronted with these kinds of fees that they have to pay. Now those who are wealthy can possibly cover these costs in some way, and those lucky few women who are able to get grants of legal aid allocated to them, those two groups will have a much better chance of safely and justly navigating the legal systems they need to navigate to ensure that their children are safe, that they have a house to live in or some financial support once they leave, and that their permanent residency is ensured. But legal aid really is still too hard to get, or is too hard to get for many of these women. And I think in part that's a result to some extent of Dietrich casting its long shadow over legal aid, and who can deny that, as we heard in the previous session, who can deny that people who are at risk of incarceration should not have access to legal aid? Of course they should. But losing one's home or one's kids is equally a troubling prospect, and women need support in these contexts. And unfortunately, whenever there are cuts to legal aid, the impact, I think, is most keenly felt by women and their children, and especially women and their children who are trying to escape abuse. We've heard today about the value of legal aid to people, and actually the savings we make as a community by providing good legal support to people. I don't think there's any doubt of that. And in terms of family violence specifically, we know that providing good legal support to women does reduce domestic violence rates and reduces the legal enforcement costs associated with family violence issues. It also importantly reduces homelessness and reduces housing precarity for women escaping violence, all of which are really important things. My most recent long-term project was a interview project with 65 women in Queensland who were in the process of leaving, and I say process of leaving because some of them left and returned over the period of time that I talked to them. But I interviewed them once a year over 3 years about their journey through the legal system and all of the different systems that they're engaged with. And many of them highlighted the issue of legal advice and representation as a key concern for them in their lives leaving violence. This was a major problem for them. And they were often part of the missing middle. They were too rich for legal aid, too rich for legal aid, but not rich enough really to pay for the private services that they would need. It's certainly not for all of the aspects of the issues that they had to engage with. So I wanted to give you a couple of examples to sort of show this. The first one I wanted to mention is a person who, and I gave women the option of what names they'd like to call themselves, but Bianca. And she and her partner Tom had separated after 14 years and had 3 kids. He'd been extremely abusive. It included monitoring, emotional abuse, but also physical abuse. And the most recent incident that led to a police call out was his suicide threat and a non-fatal strangulation of her. Police came and assisted her to leave to a shelter where she stayed for a while, and then obviously she started to engage with various legal services. So the first interview that I met Bianca, she'd been separated for nearly a year, and she engaged a private lawyer to help her obtain a protection order and family law contact and property arrangement. She worked in a professional capacity full-time. Her wage was $87,000 a year. However, when I met her at the first interview, she'd already spent $85,000 in legal fees. Her financial situation had become very complex. She said, so I paid for my barrister, I've got money left, and my mum's going to lend me $4,000, and I've managed to get one of my credit cards extended by another 7, and I'm hoping that'll cover the barrister and the other lawyer. And if it doesn't, the lawyer said I can pay them off slowly. I've got a lot of debt to deal with. I've actually put in an application to access my super on compassionate grounds for medical reasons. I've got chronic PhD, so the doctor's going to support that, and I'm going to pay the lawyer with that. In any event, over the period of the interviews, Bianca's debt totally spiralled, and the root of her high debt problems was her private legal fees. At the second interview, she'd reached the maximum limit on a whole range of credit cards that she'd been able to obtain, and this was largely due to her legal fees. And at the final interview, the third one, her financial circumstances were extraordinarily precarious. She'd drawn down her super, which is obviously supposed to support her in her retirement, and she was struggling with numerous credit card debts. Obviously, she had a terrible impact on her credit rating, so she wasn't able to get more credit cards, and she was really struggling just to move past the debt. So that was where she was left, and that was in part a result of not getting access to legal aid in her context. And the second woman wasn't much different. Fiona had suffered absolutely years of physical abuse at the hands of her partner, and she had waited till they were old enough that they could choose where to live, because she was obviously so fearful of what the family law system would require. So as soon as her youngest child turned 16, she left her partner, and there was documented extraordinary levels of abuse in this context. She was also not eligible for legal aid. Her wage was slightly lower than Bianca's, but she could not get legal aid because she had shared a house with her partner in an outer suburb in Brisbane. And so she was drawing down on the equity in the house to pay for her lawyers. By the time I spoke to her, she had $15,000 in debt, and she described her financial situation as totally cooked. And at the second interview, the property settlement had been finalised, and after paying off her debts of $25,000, she had $20,000 left over, not enough to buy a deposit in a house. So this was a woman who had lived her whole life paying off a mortgage with her partner, but was now going to be living in rental accommodation for the rest of her life. So the women's reliance on the private legal support often placed them, I would say, in financial precarity. We know this is a particular issue for women leaving violence generally, and I point you to Anne Summers' recent report, which talks about this particular issue of women leaving family violence and the financial precarity they face. And this legal debt is a contribution to this precarity. I think legal aid needs to be expanded. It's totally pivotal that abused women should have access to the legal services they need. How we do that is a good question, and it might not necessarily mean the same old models of legal aid that we're used to. I've presented before on these kinds of issues, and one of the suggestions has been HECS-like debts. Maybe that is something we can think about for certain legal aid contexts. So I think that's a really important group that we shouldn't lose sight of, and that's not to say that all of the other groups we've talked about today is obviously not important to be considering as well, of course. But the second thing I wanted to highlight is the need for good domestic violence lawyering amongst our practitioners. There's so much research based largely on the subjective, qualitative interviews with people who've experienced legal services about the issues that they say that they face with lawyers that they speak to. And this research, there's many papers, but it's highlighted essentially that there's not a good enough understanding of how family violence, what it is and how it works. As Kylie suggested, there's not sufficient understanding of the effect of trauma. So that client that goes around in circles or can't remember today but can remember another time, and those kinds of issues. The screening problems that Kylie mentioned, but also some other more fundamental problems, such as not listening to the client, minimising their experiences, judging them as the nagger who creates the issue, for example, or not believing their allegations. There's also been claims in some of the literature that lawyers have told individuals not to raise family violence, especially in family law proceedings, because it makes things too complicated. There's also issues around not recognising the pattern of abuse that comes with domestic and family violence often, and the non-physical forms of violence that we know are incredibly harmful. Also the question too of recognition of the relevance of family violence in the case. And I was at another workshop earlier in the week on strategies for representing women who kill their abused partner, and obviously we don't want to get to that point, but there was an issue there about the courts not being willing to hear family violence evidence in certain cases, and I think it's likely to be relevant if it's part of the woman's experience. It's likely to be relevant to the area of practice that they're engaging with. Also, the failure to understand the impact of the violence on children and insufficient knowledge of how domestic and family violence should be dealt with in their area of law. There were other things as well. But in response to this literature, we did some focus groups with women's legal services across Brisbane, Sydney and Melbourne, and the views of the Women's Legal Service were fairly consistent about what good domestic and family violence lawyering should look like and what kinds of requirements it has. And I think these mirror Kylie's points that there needs to be a good understanding of what family violence is. It needs to be trauma informed. Clients need time, which is obviously an issue for practitioners, of course, and being non-judgmental. But I mean, I think that the competencies we require are starting to be well recognised, but they're not sufficiently present in practice. So our focus groups obviously were dealing with women's legal services, who are largely dealing with people who identify as victims of family violence. There's very little research on lawyers dealing with perpetrators of family violence and whether their practices should be different. I think one of the things that our research suggests is we need more work as to how do we understand the context of that form of practice, the dilemmas faced by lawyers in that context and how they're responded to. We have to understand that working for perpetrators of violence, lawyers working for that group also, it's pivotal that we are all on the same page in relation to domestic and family violence, and that's a long road that we need to travel. The other thing that we need to think about is the development of competency and best practice standards of what constitutes good lawyering across these settings, not just simply in family violence related to family law, but across civil protection orders, migration, criminal law, and so on. And the third is work for Anna and I, which is, I think, developing our work in academic institutions like our universities, ensuring, similarly with Indigenous issues, that our students are skilled up on these particular issues and that it's part of the routine education of lawyers. I think that's a really important place that we can certainly make our contribution, and we can start that now, really. The other thing I wanted to mention just before I sign off is that something that we've been rolling out across our universities is improved Indigenous legal education. And one of the things that has been really useful is a book that I was part of, which is called the Indigenous Judgments Project, which some of you might be interested in. It has 15 chapters, all written by Indigenous people who reimagine current cases like Bugmy through an Indigenous lens. And I think if we could imagine perhaps cases involving family violence through the lens of good lawyering, what would they look like? That might be something that we could think about doing as well. But anyway, I'll leave it there, but thanks very much.
Thanks.
Thanks very much, Kylie and Heather. And I also wanted to say thank you to John for inviting me to speak today and for your organising of this event, and also to the board members of the Whitlam Institute. I want to begin by acknowledging the traditional owners of the land, the Gadigal people of the Eora Nation, and thank Uncle Michael for that beautiful welcome to country. And I really loved thinking about cockatoos and birds, particularly at the beginning of our day. I also wanted to recognise the strong support from our Western Sydney University community, my colleagues, and the marvellous students that we've already heard from today. And in my presentation today, I recognise the contribution of law reform submissions, which I've drawn from, and some of the stats from women's legal services in New South Wales, Victoria, and across Australia, and also particularly my colleague, Dr. Amira Aftab, who's been very generous with her expertise. So in beginning this discussion, and I'm going to be talking today about legal aid service delivery in domestic and family violence for culturally and linguistically diverse women, I think it's important that we recognise the problematic nature of that term, so culturally and linguistically diverse, or CULD, as it suggests that only people who are non-white or non-Anglo have culture, rather than recognising that everyone has a cultural background. It's part of each of our identity. And for those of us who are white, myself, Anglo, Irish, New Zealand, there's a privilege that goes along with our whiteness. And talking about race, particularly in Australia, is really challenging, and we've got a long way to go. And we're just beginning to see that as we're discussing the voice to Parliament. It's evidenced in the immediate backlash whenever we discuss systemic discrimination on the basis of race, or try to understand how racism isn't an individual experience, but most perniciously is a systemic exercise of power. We need to understand the complex nature of culture and racism in order to think critically about effective legal services for culturally and linguistically diverse women experiencing domestic and family violence. So despite the problematic nature of the term, I am going to use it as it's the category that we use in Australia and raises important issues for how our law, our legal system and our legal service providers need to work with victim survivors of domestic and family violence. So my colleagues Kylie and Heather have already spoken a little bit about what is good lawyering in this area, and particularly with women from a range of cultural backgrounds. And Kimberly Crenshaw introduced the concept of intersectionality in our understanding of race and gender, saying, while gender, race and class intersect to create the particular context in which women of colour experience violence, certain choices made by allies can reproduce intersectional subordination within the very resistant strategies designed to respond to the problem. So how we lawyer with those women from culturally and linguistically diverse backgrounds who experience violence is critical. So I'll talk about some of the issues faced by women and 2 examples of legal service lawyering which is done well, and some suggested responses in domestic family violence lawyering. So some particular issues faced by this group of women. Culture and religion can operate in a range of ways to either compound gender roles or in some cases enable women to leave relationships in which there's violence. Some may perceive culture as part of the problem, not recognising complexity within culture and religion, and that culture is constantly changing, it's not fixed or defined by one group. Within one culture, there are many cultures. And in surveys of clients of women's legal services and in some of the literature reviews, the research in this area, there are some recurring problems, and I'll talk about 5 of them. One is the financial insecurity, and that perpetrators use lack of language, visa status, and lack of financial independence as a means to further violence against culturally and linguistically diverse women. Secondly, a lack of trust in police or in courts. Some of this may exist pre-migration, others compounded by being here in Australia. And if we look at the amount of police work now in New South Wales alone, 40% of it relates to domestic abuse. So we need to ensure thorough and effective training of police and a need for multicultural client liaison officers, not those who just keep referring a client on to the next police station. Police need to be able to deal with the diversity of clients who present, and it's vital that lawyers can work effectively in this area as it's experienced across cultures, and thus the understanding of systemic racism and the privilege of whiteness. Thirdly, the misidentification of perpetrators that my colleague Heather discussed or briefly, in which women are often seen as the aggressor, and that misidentification of the victim or the offender can be exacerbated with clients from culturally and linguistically diverse background, particularly if the male perpetrator speaks better English than the victim and no interpreter is used. And we have to take the whole context of the domestic violence into account. There's a need for skilled interpreters, skilled and trained in domestic family violence, as well as a language. Fourthly, the particular category of women on temporary visas. For those on temporary visas, most are ineligible for Medicare, housing assistance and other essential support services if they separate from their violent partners. They have to show a genuine and continuing relationship and that the violence occurred. And it's very difficult for the majority of those women experiencing violence to access permanent visas unless they were on partner visas. Finally, the role of specialist services for women from culturally and linguistically diverse backgrounds with disability. We need those specialist services existing within existing specialist services, so women's specialist services. And recognising that communicating with an interpreter can be particularly difficult for a woman with cognitive disability, as it may break the flow in the communication. So a range of interpreting techniques can be used to deal with this, such as taking more extensive notes without having to stop constantly. So now I'm going to turn to two examples of ways of working with women who experience domestic and family violence. One is around temporary visa holders, and the second is around a specific cultural community and a tailored response. So a pilot was established. This is the first one around temporary visas or precarious immigration status. A pilot was established in 8 women's legal services to provide wraparound services. And we've heard about this, the importance of having that multidisciplinary approach. Since October 2021, it's provided advice and assistance to women and their children experiencing violence on temporary visas, no visas, or have had their status, they have precarious migration status. So 22% of them held a tourist visa, 14% a student visa, 10% a special category. The clients are from 34 different countries with a range of religious and cultural backgrounds. The measures that they have used within these services to ensure culturally safe lawyering is those wraparound services with social workers, financial counsellors and lawyers. Training provided on migration and family violence to all the staff in the women's legal services to build knowledge and capacity to identify women requiring migration advice and assistance. Also engaging within the sector to build strong referral pathways, including with specialist family violence agencies, health services and multicultural services. Providing expert consults to sector colleagues around visa issues and creating a local network for other services in Victoria. They also recognise some of the systemic barriers that these women are facing, such as a lack of affordable childcare, and are starting to advocate for systemic change in that area. The second example is a community-specific service for Indian women arriving in Australia in northern Melbourne. And Northern Community Legal Centre in the north and northeast of Melbourne has a growing Indian population, and it's the most popular region within Australia for migrants from India. And the centre identified high levels of suicide of Indian women. Some of the research shows that women from developing countries experience higher rates of violence when they reside in a developed country than women who are not from a developing country. Newly arrived Indian brides are particularly vulnerable to violence, and it often starts or worsens after migration. And women's economic dependence makes it more difficult to leave violent relationships, and those on temporary visas are particularly vulnerable. Many of them were unaware of the visa that they're on, whether it be student, partner or other, and that can be used by the perpetrator to control the woman. Fear of being deported, separated from children is a key factor motivating women not to speak out against the violence. So the Northern Community Legal Centre, again, provided that wraparound service with multilingual workers and lawyers, social workers, and it dealt with the complexity of legal issues, not just focusing on one legal issue, and provided training to police on specific issues in the community and worked closely with them. So those are two examples of good, effective domestic family violence lawyering. So in summary, what makes, and building on what my colleagues have already raised, what makes for good lawyering with women from culturally and linguistically diverse background? And as referred to, a deep knowledge of domestic and family violence, as well as a deep knowledge of the law and how to use it effectively and its intersection with race. Secondly, the importance of training ongoing training for us as lawyers working with clients. And within our legal education, we absolutely need to take up that challenge. It's not required a deep and effective understanding of domestic and family violence. And it's not in our ongoing training or in our PLT programs as solicitors. We need to be trauma informed, and that means spending time over multiple occasions to create that trust relationship. We need to ensure that a client has agency, that they are at the centre of their case, and at the centre of the decisions, not having their legal process done to them. It needs to be wraparound, meeting non-legal needs, and we need to make sure that we are framing domestic and family violence within the law, using women's experience within those existing legal concepts. And I also think that we have a responsibility in good lawyering to engage in law reform. It's not enough just to work within the system. We have to actually, as an ethical part of our work, to contribute to the administration of justice, improve the system. So to conclude, we've got a long way to go in improving legal aid service delivery, but there are some important examples of services that we can draw from and build on.
All right, thank you, Anna. Thank you, Heather. I'm just looking for questions from the floor. One at the front. Just wait for the microphone. Yeah.
Sure, I found that very interesting, and I thank you for your advocacy, each of you, in what you presented. I couldn't help but just keep thinking, as a family law barrister, specifically, some of the challenges that we advocates have in the work we do. And I find, having acted for perpetrated, those that perpetuate false narratives, those that continue to lie, that they haven't done it, but they have done it, perhaps all of those problems are extremely vexing in the family law system. And ultimately, the outcomes that we're trying to identify is really just protecting the child. And I find that the biggest gap that advocates have is connecting that risk profile that exists or manifests from those examples I've just given and protecting the child. And I feel that more can be done in drawing that nexus between using the court as a platform for hearing family violence allegations, but more specifically, the nexus between intimate partner violence and the risk to a child, because the family violence can come in very, very various shapes and forms, insidious, intimate partner, specific or otherwise. So that's one observation I wanted perhaps any of you to comment on. I had one specific question as well to Your Honour, which was whether or not you're finding 102NA scheme, whether that scheme's proving to be effective in circumstances where my personal reluctance to take on that work seems to be that I can't get a grasp of the entire case to forensically put the cross-examination that one would need to for that discrete aspect of the case. So how does one step into the shoes of the person putting forward their case and putting forward the propositions that one must, but only come in for that aspect of it? So I'm just wondering whether you've had any observations of that practice.
Well, in some ways, and I don't want to be critical, I don't really understand that problem, because that grant, as I recall, is the same grant that essentially is equivalent to the same grant that anyone else under a grant of legal aid gets. This is at the pointy end, preparation and court. So it may be the question highlights the problem that I'm talking about, that there's a lot of work that needs to be done to get your head around it and prepare it in a way that, as a panel, I suppose we're saying might be necessary. And there is then a reluctance of people to do the work for those sorts of reasons, and that potentially leads to problematic outcomes.
I thought, and might be wrong, I might be, that the 102NA grant is the role is just for the cross-examination.
No, it's not. It's for representation, so it involves, and I've got Alex Colquhoun who's in the background here nodding, but Alex is the Director of Family Law at Legal Aid New South Wales. But look, I think what you're raising is attention. I also, just in relation to that other comment you made, would just say this. that the entire focus for a judge is risk and making sure that an outcome is risk-free. From the point of representing someone where there is an allegation of risk, if your client's instructions are, it didn't happen, I never saw it, she's making it up, if they are the instructions and that's what goes into an affidavit, if I make a finding that is contrary to that, then your client's case has completely fallen over because they've taken no responsibility, they've shown no insight, and so I think that there is a real nuance, and it's complex. I understand it, but there is a nuance because that style of, which is, I think it maybe comes from the criminal law jurisdiction. You're either guilty or you're not. We work in grey in family law, and everything is in the shades of grey. I'm not sure, Heather, because you also cross that divide of criminal law and family law, whether you'd have any observations about that issue?
I mean, I think the siloing issue is a problem, and I don't know if this happens in New South Wales, but I know that in Queensland, family lawyers often send the intervention order stuff off to criminal lawyers, and criminal lawyers use the intervention order scheme as a way to give their junior lawyers some experience in cross-examination, which I find, deep. I totally understand how that's all happening, but it's a really problematic model if we're doing it that way, I think. Treating one thing as highly adversarial and seeing that there's different skills where they're not necessarily that different, and this means that someone has to disclose their issues to two separate people, or, I think there's real issues about the siloing of our lawyering, I guess, around family violence issues, and the fact that someone might have to have contact with 3 or 4 different specialists. I'm not really sure how you manage that because obviously they are different kinds of skill sets, but better communication and sharing of the stories and so on, so to minimise that risk of re-traumatisation. But yeah, these are all kind of complex questions to try to resolve, for sure.
Now, I'm not sure, John, we're yes. All right. So, is there one more question we can take, and then I'm happy.
There was a woman at the front here in the second row.
Did you have a question?
Oh, someone's desperate.
Sorry, I've got someone right at the back, desperate to ask a question.
Ruth.
Thank you to my former boss. Can I say, having worked yesterday with a young Arabic-speaking lawyer with a non-English speaking woman who's experienced family violence, I do think that part of the answer is to encourage our legal aid lawyers. Sorry, I should say, hello, my name's Ruth Pilkington. I'm a proud legal aid lawyer. And we were working across a number of different areas. In the success we had with our client yesterday, she came to us with an issue involving parenting, divorce, child support. The former partner of their 5 children is continuing to use coercion and control to incorrectly give information to Centrelink. The big success we had yesterday was that we wrote a letter to support her review to Centrelink, which resulted in a $16,000 family tax benefit debt being waived. But what she came to us about yesterday was that she's been given until the 8th of March by the Tenancy Tribunal to move out of her home. Housing is just such a critical issue for the people that we see who experience domestic and family violence. So can I just put my other hat on, which is the chair of the Greater Sydney Family Law Pathways Network, and I'd like to plug a session that we're doing on the 15th of March online, which is about working with people who are accused of using family violence. So we will have someone from the Family Advocacy and Support Service who works with men.
Yep.
We'll have someone who is a very experienced practitioner, Alex Wern, who many of us in this room will know, and who's worked extensively in this field, talking about practical ways of working with people who are accused of violence. And we'll have someone who's a very experienced person providing men's behaviour change programs. So I just encourage people to attend that event as well. Thank you. It's online. Look out, Greater Sydney Family Law Pathways Network. Thank you.
All right. I think we'll need to wind it up. We're standing in the way of you networking and drinks, so I'll hand it over to John.
No, I do apologize that we have not only run out of time, but gone over. These are conversations which are so extraordinarily important, but we can't think that they are intractable. And I thank you for your questions and your passion. And it was for both panels. And of course, I would love to extend my gratitude to Anne-Marie Lumsden, the Director of the Northern Territory Legal Aid Commission, who was integral to putting this program together and constructing these panels. Thank you very much, Anne-Marie. And it would also be remiss of me not to thank Chief Justice Alsop for allowing us the use of this space and his wonderful staff, and of course the time of the Attorney General, both Commonwealth and Northern Territory. Your time is very short at this very important time in our nation's history, and I very much feel very proud and privileged that you found the time to come and speak to this forum. So thank you very much, Chancey. On behalf of the board of the Whitlam Institute, I would make note that this, of course, is a 3-year period in which we are celebrating the 50th anniversary of the 1972 election of the Whitlam government, and considering its legacy and the contemporary relevance of that legacy. This is the first of our inaugural series of CPD events. I do hope that you will be able to join us for our next events. But let me not speak any further, invite you out to the foyer to continue your networking, and thank you all for coming. Thank you and good afternoon.